And I'm a new member of the worship committee. I just joined this spring. And being a congregation with a half-time minister, we're lucky that we get to have guest speakers fill our pulpit. And I'm very happy to introduce Rich Saltzberg to speak with us today. I apologize that I got his byline wrong. At the top of your order of service, there's a T missing from his name. It's Saltzberg. Rich was a freelance journalist with the Martha's Vineyard Time in 2014, and then in 2017 he became a full-time reporter and worked for the Martha's Vineyard Time until January of this year, when he began working for the Martha's Vineyard Commission as their Development of Regional Impact Coordinator, also known as DRI. He was named Reporter of the Year by the New England Newspaper and Press Association in both 2020 and then again in 2023. And he was the first place recipient of the New England Newspaper and Press Association's Right to Know Award in 2022, and then again he won 2 more awards in 2023, this past May. Rich is originally from Essex, Massachusetts, the home of the fried clam. He graduated with a bachelor's degree in creative writing from Emerson College, and then he pursued an MFA in writing from Florida Atlantic University. He is also the awardee of the Wintermaker Creator Fellowship. He currently lives in West Tisbury with his wife Amanda, daughter Electra, and their dog Carolina, and their fish Bubbles. Welcome, Rich.
Hello, Unitarian Universalists. It's good to be among you. Who's ready for some public records action? All right. Can you hear me okay?
A little more.
How's that? Is it pretty good?
We can turn it up.
Or I can use the handheld one if that would be easier. I'm happy to. Your call. Oh, there you go. Look at that. I stepped on a wire and it's working now. Is that good? Okay. Okay. Why am I here talking about public records? Public records were central to my former role as a reporter for the Martha's Vineyard Times. I came to the Martha's Vineyard Times in 2017. I didn't have any public records experience. It wasn't until 2019 that I started to dig into public records. That year, the Steamship Authority responded to my request for various leadership emails with an enormous proposed fee. And also that year, the Tisbury Police Department responded to my request for reports related to an alleged school threat with a blanket denial based on multiple exemptions. I appealed the Steamship Authority's response to the state's supervisor of records and emerged with thousands of pages of emails, even though I didn't know what I was doing. I appealed the Tisbury Police Department's response and eventually got all the material I sought, even though I was essentially feeling my way around in the dark. In both cases, Massachusetts records law was on my side and placed high burdens on those two records custodians. I was actually lucky with the Steamship Authority emails because the scope of my request was vast, and it wasn't unreasonable for them to request a fee in that instance. They made the mistake of proposing a fee after the deadline for doing so had passed, so lucky me. That gutted any chance they had of imposing a fee. Again, I was lucky. I went on to routinely seek records from the Steamship Authority. More often than not, I got the records I wanted without much of a struggle. But we did have some notable clashes. I'll touch upon one of these shortly. As for the Tisbury Police Department, there were many months when it felt like hand-to-hand records combat. more I learned about records law, the more I marveled at some of the reasoning for withholding records some of the town's attorneys came up with. In my records work with that department, I made over 30 appeals. Many of the records I unearthed there were poised to be destroyed and never would have otherwise seen the light of day. I'm proud of that work. And I should add that that department has really made quite a turnaround. It's quite a different department now, and they've really made great strides. So they did have some trouble in the past, but I don't think it's characteristic of the way they are now.
Thanks to you.
So, public records are not solely the purview of journalists. Not at all. They're everybody's resource, and everybody can access them. Journalists make good use of public records and can disseminate or interpret those for large audiences. However, I would argue we inhabit a stronger democracy when the public seeks and reviews the records their tax dollars have paid for. Think about this as sort of an incremental audit. To quote the justices of the Massachusetts Supreme Judicial Court on a case I'll speak about shortly, the public has a recognized interest in knowing whether public servants are carrying out their duties in a law-abiding and efficient manner. And at the very beginning of an online resource that I highly recommend, a state resource, a guide to Massachusetts public records law. Excuse me a second. Hydration is always essential. At the beginning of that resource, it states, the founders of our nation, quote, strove to develop an open government formed on the principles of democracy and public participation. An informed citizen is better equipped to participate in that process. So that's your own state laying out that statement, which is encouraging. So what is a public record? Every document produced by a state, regional, local, or state agency, state, regional, or local agency in Massachusetts is public unless specifically proven otherwise. Every email, video, photograph, every report, every invoice, tabulation, or spreadsheet. Even the metadata in an email or electronic document, who sent it, when, who received it, the IP address, it's all public. Most public records aren't publicly posted. That doesn't necessarily mean anybody is hiding anything. It would be very difficult, especially at the local level, to publish every record a municipality generates. Think of a town annual report. All the facts in the report stem from thousands of public records created over the course of a year. Records that civil servants have boiled down into a small book. Public records are a reflection of how your tax dollars are being spent. In whatever town you may live in on the Vineyard, and I know some of you aren't from the Vineyard, so wherever you are from, for instance, you've paid for the creation and storage of every single municipal record. If you want to see a month's worth of electric bills for a water department, you can under the law. If you want to see all the emails in a given month between your tax collector and the Massachusetts Department of Revenue, you can under the law. If you want to look at a select board's discretionary expenditures for a given year, including receipts, you can under the law. If you want to see construction contracts for a given project, you can under the law. If you want to see police reports, you can under the law. With caveats, I should say. How do you ask for them? How do you make requests? Some folks refer to a request for public records as a FOIA. That's inaccurate in Massachusetts. FOIA is an acronym for the Freedom of Information Act. Requests under FOIA are for federal records. In Massachusetts, the request is made under Massachusetts Public Records Law. You can simply call it a records request. Other states have their own laws governing records, and some may employ the term FOIA. We don't here. Requesting a public record is simple, and you never have to give a reason why you're asking for it. Never. Don't let anybody try to inquire about your motives. It's your right to ask for your own reasons, and you don't need to give them. For vineyard towns, for instance, it's best to start with an email to whatever department you think the record hails from, and CC the town clerk. So, for instance, if you want invoices showing how much road salt the town's DPW bought in a given year, you would email the head of the DPW or the highway department in that town and copy the clerk. Always copy the clerk, because the clerk is most often the town's records officer. And the records officer eventually always has eyes on public records requests. It's unwise to request records over the phone or in person, because there's no record of the request you made, and that can come back to haunt you. There's no evidence that you made the request, basically. Email is the gold standard. Once a town or agency has received your email, they have 10 business days to reply. If the request is easy for them to manage, they will most likely just provide you with the records within 10 business days. If they think it's too broad a request, or think the records may require redactions or research, they're more likely to give you a response that asks for more time, or sometimes asks for a fee. Try never to pay a fee. But always give a town more time if they ask for more time. It's a reasonable thing to do, and your experience will likely benefit from the courtesy. And speaking of courtesy, it's always good to be polite in your requests. It's fine to be matter of fact, but don't be demanding or accusatory. That never goes over well. Always try to conceptualize the volume of records that you are requesting so as not to be too broad in scope. What do I mean by too broad? Less is more in records requests. If your goal is to harvest a year's worth of certain emails, for instance, it could be considered overly broad to ask for them all at once. It's better to break up the requests. Ask for 1 or 2 months in a given request. That way the custodian can't argue it took a lot of time for them to assemble what you asked for. Massachusetts records law is subject to exceptions and exemptions. 3 really big exceptions are the governor's office, the legislature, and the courts. All 3 are immune to records requests under Massachusetts public records law. Perhaps only one other state in the Union shields all 3 core branches of state government in that way. Concerning the courts, you can always request court documents in the district or superior court clerk's window in Edgartown. By and large, you can see most everything. The material is considered public, but it's not subject to public records law in this state. Certain cases can be sealed or impounded for numerous reasons, or parts of those cases can be sealed or impounded for numerous reasons. The exemptions to Massachusetts public records law are listed by letter codes. Exemption A, Exemption B, and so on. There really are only a handful of these exemptions that come into play regularly. Only a handful that you would encounter, most likely were you to make a records request and an agency or municipality were to say, you know, we think this is exempt or partially exempt. The remaining exemptions are a bit more exotic. Most of them I've not encountered in the course of 84 appeals. Generally speaking, exemptions don't often sideline entirely a record, but a portion of it. When exemptions individually or in combination are alleged to exempt the whole record, that's called a blanket exemption. Never stand for a blanket exemption. Appeal it. There are some records you just cannot have. It took me a while to accept that fact. Among them are records that have to do with attorney-client privilege, most autopsy records, records about archaeological sites. They keep archaeological sites secret so people don't pillage them. And student records. Now, what do you do if you feel as though a municipality or an agency or a regional government agency has denied your records request in part or in whole, and you feel as though, they didn't have it right. Well, you appeal. We're fortunate in Massachusetts to have a division of the Secretary of State's office dedicated to evaluating appeals of records requests. It's called the Supervisor of Records, which is both a person and an office. If you feel your request has been unjustly denied, if you have been subject to a fee, if you've received no response from a records custodian, you can lodge an appeal with the supervisor. That appeal will be answered with a determination in 10 business days. It's a free and terrific service. You do it by email. Outline your reasoning as best you can, and make sure to provide copies of that request, of your request, and the response you received. All right, I'm going to describe now a particular case that went before the Massachusetts Supreme Judicial Court, which informed a particular set of appeals I did to help you sort of get a little bit of a flavor of the back and forth that I went through to ultimately get the records. And also maybe to give you a little bit of an idea about how records work at the highest levels. So essentially, most records can be managed at the supervisor of records level if there's a dispute. But if for whatever reason you're dissatisfied with what the supervisor of records comes up with for a determination, or if you don't even want to go there and you're feeling a little spendy, you can go to the Superior Court. And the Superior Court has parallel jurisdiction over Massachusetts public records law. And that's where we'll begin here. In 2017, the Massachusetts Supreme Judicial Court made a landmark public records ruling. The case stemmed from a records request made by PETA, not the bread, but the welfare organization, animal welfare organization. PETA asked the Massachusetts Department of Agricultural Resources for, and I'll quote, any and all permits, licenses, health certificates, and other documentation related to the export and or import of non-human primates in Massachusetts during 2013. So essentially they were trying to track test animals, more or less. The PETA received a response from that department. However, it was redacted, and it was those redactions which PETA fought. Per the decision of the Supreme Judicial Court, the department redacted the certificates, three categories of information: the names and addresses of consignors and consignees, the United States Department of Agriculture licenses or registration numbers, and the names and addresses, telephone numbers, and license numbers of all the veterinarians whose information appeared on the health certificates. In making the redactions, the department relied on two exemptions. The first one is Exemption N. And the second one, which it brought about later, it didn't originally muster, is Exemption C, which I'll describe a little bit later. So Exemption N, I've encountered in the past. Exemption N came about after 9/11 and was designed to keep records of public infrastructure like blueprints and security plans out of the hands of terrorists. The two prongs of the exemption are whether, in the reasonable judgment of the records custodian, the release of the records is likely to jeopardize public safety, and whether the records resemble what's described in the statutory description of the exemption. And this is the statutory description. Records including, but not limited to, blueprints, plans, policies, procedures, schematic drawings, which relate to the internal layout and structural elements, security measures, emergency preparedness, threat and vulnerability assessments, and any other records relating to the security or safety of persons or buildings, structures, facilities, utilities, transportation, cybersecurity, or other infrastructure located within the Commonwealth. A more succinct description of what that all means was given by the Executive Office of Public Safety. They summed it up by saying the exemption exempts records that a terrorist would find useful to maximize damage. So the Massachusetts Department of Agriculture reasoned that if it disclosed the redacted information, it could compromise the security of locations housing non-human primates, thus increasing the risk to public safety of the animals as well as the people and buildings involved with housing and transporting animals. PETA didn't like that. So, and I should say, the state generally treat, almost always, it will treat PETA or a reporter or you equally. So just because they're an animal welfare organization didn't give them particularly any more clout or less clout than anybody else, but they just happen to be the litigant. So PETA appealed to the supervisor of records, and based on the information the department provided, that included some supplemental material, the supervisor upheld the exemption. PETA sued in the Superior Court, and the exemption was upheld there too. And they added another one, exemption C. So they weren't satisfied with one, they threw another one in because they really, I think, really wanted to cover their bases. Exemption C is an exemption that you are actually quite likely to encounter when requesting records. Unlike N. N is not so common. Exemption C is defined as personnel and medical files or information and any other materials or data relating to a specifically named individual, the disclosure of which may constitute an unwarranted invasion of personal privacy. Provided, however, this is important for, I can definitely say this is important for some work I did, provided, however, that this subclause shall not apply to records related to law enforcement misconduct investigations. So they have a balancing test for C. It's a so-called balancing test, and that's how they decide whether C is applicable. 1, whether the disclosure would result in personal embarrassment to an individual of normal sensibilities. 2, whether the materials sought contain intimate details of a highly personal nature. And 3, whether the same information is available from other sources. So the Supreme Judicial Court took this over. And they didn't, the way they ruled was, well, first they vacated the Superior Court's decision in this matter. And then they really tightened the definitions of those two exemptions. So in their evaluation, the individuals that were listed on those certificates did not have the same rights to personal privacy under the records law that commercial interests do. And so they reasoned that because they were veterinarians, for instance, veterinarians normally advertise their phone number, where their business is, things of that nature. This was business information. And they didn't say to the Superior Court, this is our interpretation, you must go with it. They said to the Supreme Judicial Court, this is our interpretation, we're vacating the other order, now we would like you to consider this. And they did the same thing with exemption N, where they said, well, they said two things. First of all, you need to really think about whether or not these records are going to create a public safety hazard. And then you also have to see if these records actually match up with everything that's enumerated in the statute. So in other words, they asked the Superior Court to determine whether or not those certificates are similar to blueprints, security plans, and things of that nature. And the sort of quote here from the General Counsel of the University of Massachusetts when they learned about this decision from the Supreme Judicial Court. They said, in part, for N, while it seems unlikely that the animal health certificates will pass the first test as they do not resemble other records listed in Exemption N, and this was just the opinion of the General Counsel of the University of Massachusetts as they were advising the records officers of that university. It will be interesting to see how the court rules on the second point. PETA has a reputation for protesting and other disruptive activities at animal research facilities, and whether those potential activities rise to the level of jeopardizing public safety so as to protect those involved with such facilities is a question for the court to determine. Now this gets kind of, unfortunately, anticlimactic, because when it was remanded to the Superior Court, the record really runs dry. So what you're left with is the Supreme Judicial Court really helping narrow and tighten the definition of those two exemptions, but I've never really found out, even by looking at the record online, what happened in the Superior Court. It appears as though that State Department, which was represented by an Assistant Attorney General, and PETA just decided to settle. And they never really disclosed whether or not, it didn't appear that this happened, that the Superior Court had to make a determination. So perhaps either side was not overly enthused at what might happen if the Superior Court weighed in. So PETA was never in my mind until 2020. I didn't know anything about it. But in 2020, in the midst of the pandemic, right over here in Vineyard Haven, one of the transfer bridges had a set of counterweights snap and fall into the harbor. And the transfer bridges are essentially ramps that go onto the ferries. And they're supported by these big weights in order to keep them level at the right tide and keep them level based on the weight of a vehicle coming onto the boat. And so it was a big deal. They had a crane over there to try to fish the thing out. And what was really somewhat alarming was the ramp essentially pinned the Steamship Authority ferry Martha's Vineyard to the transfer bridge. Because if the ferry were to pull away, the ramp would have dropped into the water. So, you know, I'm down there talking to people and taking make a request for these videos because that'll tell us, you know, what really happened, or at least show us what happened. Because it was a long time, many meetings had to take place before you really got an answer as to how it broke. And their answer was that there was a bearing that froze on the transfer bridge, and in freezing, it not froze from temperature, but froze from corrosion or friction or some reason they didn't really elaborate on. And that made the wire so taut, it just parted, and the cable fell in the water. I had kind of heard something else, and I was curious. So I made a records request. I made this records request in May when it happened. My fight with the Steamship Authority went back and forth just between me and them in emails until November, when I finally got an appeal back from the Supervisor of Records. And they applied PETA, or the Steamship Authority attempted to apply PETA to this case. They attempted to classify that footage as potentially something that a terrorist might find advantageous to maximize damage. And in my mind's eye, you know, I was trying to conceptualize whether or not that actually was valid, because a 20,000 pound set of counterweights just missing a couple of Steamship Authority employees on a ramp and then falling in the water seems like a more real and present danger than whether or not video from cameras everyone can see in an open environment where that's heavily photographed is going to be disseminating information that should be kept secure. In other words, it didn't seem like that was a very secure environment to begin with. So, long story short, I'll put up a picture of the determination from the Supervisor of Records. Or I will try. Well, I don't know if that's going to work.
Rich, do you want me to do it?
Sure.
Which one do you want? October 2020 or September 21st?
October 2020. You folks will sort of get an idea of what a determination looks like. Oh. There, okay, that's what the Supervisor of Records determination looked like. They gave Sean Driscoll, the Steamship Authority's public information officer, and credentials he didn't have. He's not an attorney, but they threw that on there just for the heck of it. I had a lot of fun with that. I ribbed him about that for a while. So basically, the Steamship Authority claimed they tried to use PETA, their interpretation of PETA, and also Exemption A, which is the statutory exemption. If there's any law out there that would prohibit the release of a public record, Exemption A would cover it. And I argued vigorously against it. And in the end, the Supervisor of Records requested that they send a copy of the video to the state, and the state will look at it and make a determination. The Steamship Authority never did that. Instead, they gave me a 40-page denial. It was, in parts of it, they had actually cut and pasted parts of the Federal Register and just stuck it in there. It was, and with the other things I was working on, it was really a mountain to climb to try to respond to that. So I let it ride. And I didn't forget about it, though. I never forgot about it. And my editor never forgot about it and would remind me from time to time, remember that time you tried to get that video and you didn't get it? So, you know, a lot of other things come and go. And then in 2022, I mean, there had been other cable accidents. Cables have definitely broken on those transfer bridges numerous times, and we covered them. But the counterweights was something different. Like, the cables seemed dangerous because when they snap, you know, if someone got hit by them, that would be serious. But that seemed, you know, less dramatic, even though that's dramatic, than these weights falling. These weights were enormous. And the first set that fell in 2020, so, you know, if there's a risk, you know, people should know about it, one would think. So it happened again in the August of 2022. And I definitely hadn't forgotten about it. And, you know, I was fortunate enough that year to win a Right to Know award. And in the description of the Right to Know award that I won from NEMPA, they called me the Harry Houdini of public records. I was like, all right, that's a lot to live up to. What's Mr. Houdini going to do about this, right? Because, you know, if somebody gives you that lofty title, you got to kind of try to live up to it. So I requested the video from that incident, and I got the same type of responses. And here I can show you, if you can put up the other one. It's very similar to this one.
This is
2022.
2020.
They look very similar. There's a difference, though. What the Steamship Authority was arguing was pretty much the same. I made my arguments pretty much the same. But what the Commonwealth did was different. The last time, in 2020, they said, we would encourage you to send the video because we'd like to see it. It's called an in-camera inspection. They weren't as, open-ended about it this time. They ordered the Steamship Authority to produce the video. And the Steamship Authority didn't produce the video. The Steamship Authority said, well, they didn't say anything. They did not comply with the order from the Supervisor of Records. So we were in the newsroom going, what's going on, you know? What do we do from here? So they came up with other ideas. They said, well, you're going to have to talk to the Coast Guard. You're going to have to talk to TSA. And I started making calls, and making a lot of calls, and bringing it up in open meetings, which they never like. You know, at the end of Steamship Authority meetings, there's a question and answer period, and I'll be raising my hand. Hey, Bob Davis, what about that video you're not giving us? Like, what's behind that? You know. So in the end, after really hammering them, they. Excuse me, just a second. In the end, after really hammering them, they found a way to get this video to the TSA. I don't know why they didn't do this before. And the TSA looked at it and said, there's nothing the matter with this video. This is not sensitive information. And all of a sudden, they produced the video. It was marvelous. And you know, the video actually, for this 2022 incident, actually verified what they claimed happened. They claimed, not for the earlier one that pinned the vessel, but for this one, they claimed a truck came on board, and the truck somehow snagged a cable and lifted up the weight, and then dropped it. And by dropping the weight, it just snapped the cable. And the truck driver was telling us that didn't happen. So we had no way to verify that. So then we got the video. And wouldn't you know it, you can see a truck coming over the ramp, and there's this pipe-like thing protruding off the side of the truck. And all of a sudden the weight goes up, splash. So they were fighting tooth and nail not to give us the video that would have verified what their description of what happened was. But we got it. We finally got it. Anyway, I guess to wrap it up, the persistence is what paid off. Sometimes with public records, you've got to be tenacious, and you know, not let them get to you. Repetitive, tenacious, and I think that's the long and short of it. I'll close with that. I'll say this one more thing, that, you know, again, public records are your purview as well. They're not just the purview of journalists. You know, you have a healthier democracy and society when the public inquires about them. It's sort of like a mini stress test. You know, can you produce these for me? Is there going to be a problem? It doesn't matter what you're looking at. And if you encounter any kind of resistance, just be polite and persistent, and records law will usually work in your favor in the end. That's a wrap.